Welcome to Health Law Talk, presented by Shahardi Sherman Williams. Health law broken down through expert discussion, real client issues, and real-life experiences. Breaking barriers to understanding complex healthcare issues is our job.
And good afternoon, everyone. Welcome to another edition of Health Law Talk here at Shahardi Sherman Williams. In the station today, your wonderful healthcare attorney host, Conrad, Meyer, Rory Bellina.
Good afternoon, everyone.
And today, it's been a slow start to the year. We admit that, but today we felt it was necessary to come on and do a show on the decision recently, or the leaked, I can't even call it a decision, but the leaked opinion in the Dobbs versus Jackson Women's Health Organization case, the case that now everyone is claiming could overturn Roe v. Wade. So, interesting situation, Rory.
Yeah, I think we were all either following the news or watching TV. I think this was Monday night when it came out that there was a leaked decision that Politico got a copy of, and then the decision made it out there, and it was roughly 100 pages. And from what we can tell, it was a first draft that was circulated internally by the justices in February of this year. So we don't know anything more than that. The Chief Justice came out and spoke this week and said that, yes, this was a draft opinion. He didn't really say more than that besides directing the U.S. Marshals to open an investigation on how it was leaked. I don't remember this ever happening in my life, but regardless, it went from there. But the court's kind of been silent since then, and everyone expected them to come with a decision on this in June, right before they kind of took their break. But here it is. And so everyone's had a chance to dissect it, and we thought we would do it and try to focus on it as much as possible from a healthcare perspective.
Well, and also from a legal posture perspective, and honestly, from both a healthcare and legally, from just a legal, because sometimes I think that gets lost. I mean, when you mentioned a moment ago about a leaked opinion, and you haven't seen that in your lifetime. I haven't seen it either. And as lawyers, I sat there and I watched the TV I was in awe, honestly. I could not believe what I was seeing. Now, I clerked in federal court for a federal judge. I worked as a research attorney for a federal judge, and while I was there, the very first day I walked in that courtroom, he brought me to chambers and said, "What goes on in my chambers, what goes on in my courtroom stays in my courtroom. You don't tell you anything, you don't do anything, everything stays in-house." So I've always assumed that, especially, to honor the institution, the integrity of the institution. And what I saw in this leaked opinion just blew me away.
Sure. And it's not just a screenshot or
it's the whole opinion
or pictures of it. I mean, it's in the official formatting and font. I mean, you could tell that this was prepared by a law clerk, and this is a draft that went around. So, it's really interesting that it happened. But moving on from that point, I think it's important that we look at, what it says, what it references regarding Roe and Casey, and then how, I'd like to talk about how we see this affecting healthcare going forward.
Well, and I agree with that. So first, let's focus to your point on the first point about how it affected Roe and Casey. I see a lot of people commenting on this, and they have no idea what it means. They think they know. They think they understand it, but that somehow now this is going to ban abortions, and it's all done. And that's not exactly what it did. It basically analyzed Roe and Casey decisions and looked at Roe as a quote exercise of raw judicial power, meaning that it took away the state's rights to vote on what they believe was state issues, and it created its own, its own paradigm, its own rule for regarding the abortions. And what the analysis on the Roe and the Casey case said, that there was nothing in the Constitution about that. There was nothing that ever specifically said a right to an abortion in the Constitution, and that Roe created this right, and pulled the right of states to vote on it away from the states. And so when looking at Roe and Casey, this opinion basically grants the states to determine its own course.
Yeah, I think that was really important. A lot of the I think a lot of the media tried to distill or water it down when this opinion was leaked out as, kind of what's like the big point or what's like the big caption that's going to capture attention. And everyone said that this is going to ban abortions, or this is going to, you'll go to jail if you have an abortion. But that's not really it. And I think it's important that you go back and you look at Roe, which was, I believe, 73.
That's right.
It was late 69 when it was eventually brought through the courts and argued in, that was the 70s. That was that post-Vietnam era. And a lot was going on. The plaintiff in the case, it's a pseudonym for it, Jane Roe. Instead of doing John Doe, they did Jane Roe. But it was all about, was it a constitutional right for a pregnant female to have an abortion at the time? And that's kind of what the case hinged on in Roe. And the Supreme Court at that time decided that it was a constitutional right, essentially for a woman to make that decision. And that went along for a long time. I think Casey didn't come along until 92 maybe. I think it was 20 or 10 or 20 years later. It took a while for Casey to come around, but all that it did was it said that it was a constitutional right. So it kind of, like you mentioned, took away the power from the states and put this in place. And then Casey came along and kind of put in this undue burden test, which if we were doing a con law podcast, we could talk about that for numerous episodes. And they had in there these different criteria. And in Casey, the undue burden was, I believe it was telling your husband was the one that was an undue burden. And then now we have this one out of Mississippi that went through the
Jackson's Women's Health Organization. Mm-hmm. And interestingly enough, and to your point to Casey, it talked about undue burden, and they were hoping, I think, in Roe and Casey to sort of have this very divisive issue seem to flush out, and it never seemed to flush out because states kept on enacting different laws within that state that sort of half addressed or try to get around Casey, if you will. And so now this is very interesting. This case, this Jackson Women's Health Organization put together a new law in Mississippi, and the argument, I think, from the government was, hey, you can't really slice and dice this anymore. You either have to overrule Roe, or affirm it going forward. There's no more half measures.
And I thought that was a really unique strategy. And if this decision holds true, I'm sure the people that I believe Jackson in this case was the health clinic or the health organization. In this case, they might regret doing that because they said in their arguments, there were snippets of their oral arguments in the Supreme Court, that they essentially told the Supreme Court, we can't have it in the middle anymore. You either have to overturn Roe or you have to affirm it or reaffirm it.
Because remember, the Mississippi rule, the law was that it would prohibit abortions after 15 weeks of pregnancy. And so the argument from the government was, well, wait a minute, if we allow the Supreme Court draft opinion was, if we allow this to go forward, then technically it would be no different than overruling Roe and Casey anyway.
Sure.
So it came down to this, well, do we overrule Roe and Casey or not? And that's what the decision was. And of course, as the draft opinion, again, not a binding opinion, it's just a draft opinion, quote, we hold that Roe and Casey must be overruled. And they say that they go further to say that Alito says the Constitution makes no reference to abortion and no such right is implicitly protected by any constitutional provision. And then they go through the analysis of okay, there's a prong test to determine whether or not abortion is held in our national traditions and in history, and some sort of a prong test. And ultimately they decided that it did not.
Right.
And so the question is, and I see it from a pure legal perspective. Take the substances out of Roe v. Wade, right, and put another issue on it, right? Do states have the right to democratically decide the issues that they want to either ban or let go forward or not?
And what's really, I keep saying what's really interesting, I've said that a few times already, I keep thinking of more things that are interesting, is that states have been doing that in the background for years. I think we're up to possibly 16 states right now that have already enacted legislation. I think it's being called in the news like a trigger effect.
Not 16, 26.
26. I'm sorry.
26 states, the triggering
So
effect,
the
yes.
moment that if this were to be overturned, it's already there. The groundwork has already been done. So,
Right.
I think that's a really important part that everyone has kind of relied on Roe as this backstop to protect them, but states have moved past it, and we're kind of split down the middle with 26 states already, making progress and deciding that they want to enact legislation that will ban or prohibit certain types of abortions, pending if Roe were ever to be overturned, which, according to this draft, it looks like it's going to happen.
And see, here's what I follow a lot of the news media and people who are just, going off the rails and not really reading the opinion, because it clearly states in the draft opinion, quote, "It is time to heed the Constitution and return the issue of abortion to the people's elected representatives." I mean, what more democratic way to decide whether or not you want to are for or against this within your state, and using the democratic process to vote for people that would then vote the people's will.
Exactly. And I think that's very important to hit on, that this is not banning abortions, or this is not prohibiting abortions. It's returning the choice to each state to decide how that state wants to govern itself on this topic.
And Alito's draft opinion actually does that. Alito's opinion actually does that. I think if you look at Alito's opinion, I would tell you that, quote, "The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. That is what the Constitution and the rule of law demand." So if you're a pure democracy type of person, which I don't think anyone would argue that we're not for the democratic process, we're not for democracy, then from a pure legal argument, take away the fact that it deals with abortions, it could be any other issue that may be federally legislated, similar, then to have this opinion return the right to govern themselves to the states, I think is a very important legal issue.
Yeah, and it really comes at an interesting time that we're coming out of COVID, we're coming out of a lot of the vaccination requirements and restrictions. We had CMS workplace, we had private employer, all that. So
Right.
It's really an interesting time that they're picking up such a big case, because a lot of Roe, first and foremost, or this case is really a con law question, but it also hinges very heavily on healthcare and what the government does
Right.
allow or doesn't allow you to choose to do to yourself or to your own body, and then obviously with states. So it's an interesting time. I think it was, it could be coincidental or not that it's coming after COVID, but regardless, I think it's got big effects on healthcare systems, healthcare providers. I know you and I were talking about that a lot offline.
Before the show.
Yeah, how is this going to proceed? So let's just assume, we'll be very clear, that this is a draft opinion, but let's assume that it's a 5-4 vote and essentially Roe is overturned.
Right.
So let's assume that occurs. What do we see? And we could talk about Louisiana, but then nationwide, and I don't know all 26 states what their procedures are, but at least here in Louisiana, we know that there's some things that will kind of happen immediately, like these trigger effects that they talk about.
Well, you have to look at the individual state laws, and you have to see what states have these, quote, trigger laws in effect, and what happens. And I'm sure that's, again, by individual state.
Right. But then going past that, it's going to become a question of, I think there's a lot of things to be unwound for this, because, you hear that different states have different regulations as far as what is considered an abortion. Is it the full medical procedure? Is it giving the Plan B or the morning after pill? There's a lot of discrepancies state by state on what that is.
Right. And you know what, if you had to do a state by state analysis, which I'm sure someone's going to do very quickly,
sure,
I think that'll be interesting. So you'd have to check your state law to determine what
right.
If you're a healthcare provider, what would be the appropriate thing to do or not do based on that triggering law.
And then there's also talking about what are the exceptions. So some states have exceptions for if there's a medical emergency. Some states have exceptions if it puts the fetus or the mother in danger. Some states have exception for rape and incest. So again, that state by state survey is gonna really be important to see, how things pan out.
Yeah, especially, I think there are some states that have the exceptions also for the health of the mother. So in other words, if there's a life-threatening incident that the mother could be in physical jeopardy, that there could have some, triggering effect to that. So I think it's state specific, but we just have to figure out what state, what the trigger is for that state.
Sure. And then in Louisiana today, there was a House committee, I was listening to it, a House committee that's trying to add language to the criminal code where if an abortion is performed, it's not only a civil violation really on your medical license, but it could also be a criminal code, and I think they're trying to get it to fall under one of the, I think it was second-degree murder. So Louisiana
for the providers,
yes. So they're even trying to go that far. So I think that this is going to be an evolving topic, and I think one thing that's really going to be interesting with it is what's going to happen from a telemedicine standpoint. Where does this go if we're in Louisiana and we've got, let's say we have a strict prohibition per se, or very tight prohibition. And I believe, and I haven't verified this, but I believe the nearest physical state where they don't have these prohibitions is Illinois. So, what occurs if you see a provider in Illinois through a televisit? Is that, but then the medication is being shipped here to Louisiana, which is where technically the abortion would be occurring because you'd be taking the medication here to end the pregnancy.
And that's assuming that the medication would be quote unquote illegal to get. In other words, the following, I have to be candid with you, I haven't looked at the Louisiana law yet because honestly, I never thought I would see what's happening
it's
right
a
now.
real trick bag because now you could have medication that's illegal to prescribe, possess, dispense in Louisiana, but not in Illinois or New York or California. So you can have it, you can possess it. It's somewhat similar but somewhat different to the medical marijuana. You've got things that are illegal to possess and distribute, consume in states but not in others. So it's legal to have it in this state but not in that state. So is it going to be, and what if it's prescribed through telehealth, but the patient is here, but they're technically seeing a provider that's licensed in Illinois, that's situated in Illinois.
All good questions, Rory. All good questions, and ones that I think are premature technically because we don't have a real opinion.
Correct.
And I guess I'm speculating, that I'm is this going to go forward? I got some alphabet soup coming out of my mouth, but I just don't know if what I've read is going to be the final signed opinion, especially now it's been leaked. You would assume that the Supreme Court would either stick with this or I don't know. But anyway, whatever happens, if it does get overturned from a procedure standpoint, then I know Louisiana does have a triggering law.
Yep.
And so I know, based on that, we would have to look and see if for example, the Plan B medication, because that's really the only thing that would apply on a telemedicine standpoint.
Sure.
Is that medication. And if that does apply, boy, is that going to be interesting if people do that and in other words, do a telemedicine service and are prescribed, and does that remote physician where it's legal in Illinois, for example, somehow does that apply to him or her if it's illegal in Louisiana?
Yeah, I think that's going to be a big mix that we're going to have to follow.
I would posture this though, Rory, because under Louisiana law, under telemedicine, even on jurisdiction, it's where the patient is. So in other words, where the patient is located. So even if a physician is out of state, they have to have a telemedicine special purpose license to be practicing that in Louisiana. Isn't that correct?
So let's assume that they do.
And so if they're doing that and they're offering professional medical services over telemedicine to patients in Louisiana, and that patient in Louisiana is receiving medication that technically is, quote, illegal or criminal in Louisiana, then I would ponder that physician is also now committing a criminal act and could be subject to board action and maybe possibly criminal action by the location of the district attorney where the patient's located.
Sure.
And definitely the board for doing that, for prescribing an illegal medication via using the telemedicine license they've issued to that physician.
Sure. Sure.
That makes sense.
No, it does. And it's a big thing that I was thinking about. Someone made, it was on the news, someone made an analogy, which, again, is somewhat similar, but a little bit different as well, of are you going to have to, as a patient, let's say it's a big state, and depending on where the providers are, but
say California,
are you going to have to? Are you going to have to?
California?
Are you going to have to cross like straight over the border from Arizona to California, and once you're inside the border, then you can get on a televisit or a telehealth call and get it, because technically then you're in California. That was a very nuanced question that they had, but I think it could have real implications for patients, and patient access is a big thing.
Well, I guess one thing, if let's just extrapolate on what could happen. So if hypothetically, let's just say that it is overturned and the right of individual states to govern themselves on this issue through this democratic process is now given back to the states. It's given back to each state in the republic. So the triggering events occur. So immediately 26 states would now have abortion as illegal in that particular state. So I would think that the other states, and usually from what I read or what I saw on the news, was that mostly the Midwest and the southern states have banned it, and the coastal states have approved it. I'm speaking very generally, of course. So that would mean that a patient would have to drive, like you just said, across the country to go to Illinois or California, or the East Coast somewhere to have an abortion, if that is the case. So I agree. It definitely is an access issue, but it's a tough one. It's a real tough one, without getting into the substance of Roe.
Sure. So I think, provider-wise, I think it's going to be important for providers to
need to know the law,
to follow this as much as possible, because there could be, big changes that come, even if you're in a hospital setting and you're not even just if you're an OBGYN, or if you're a primary care physician, and you have to follow this, because it could become overnight where you prescribing some sort of contraceptive or I don't think it goes as far as birth control, but like the Plan B pill, like overnight you could be having criminal implications if you by not following this.
If your state law has something that goes to that level.
Correct. So I think it's important for everyone to follow this as close as possible. Definitely check in with their state law, with their state attorneys, if their patient base is something that of females that could have children, because it could be something that could definitely affect them.
Agree. I think so. I think we'll see what happens. We're going to monitor this. We're going to put this on the table, and we're going to monitor it and keep ourselves on the pulse of what happens. I mean, how can we not? It's going to be in the news no matter what. When it comes out. So we'll be on top of this, and we'll let our readers know, our listeners know exactly what happens. And we'll, I think the next time we get on air, once the decision comes out, let's pull a sampling of some of the states that are triggered, and depending on the ruling, if it does overrule Roe and Casey, and then see how that affects those triggering states from a legal perspective as to healthcare providers.
I think that's a great idea.
All right, great. Well, look, thank you very much, Rory, for coming on the show today, and everyone else who's listening in to Health Law Talk here at Shahardy Sherman Williams. You've got two of the best healthcare attorneys in the area, Rory Bellina, Conrad Meyer, giving you the latest and greatest updates on healthcare news, legal policy, you name it, in the healthcare field. Stay tuned, and we'll see you soon.
Thanks for listening to this episode of Health Law Talk, presented by Shahardy Sherman Williams. Please be sure to subscribe to our channel, make sure to give us that 5-star rating, and share with your friends. Shahardy Sherman Williams is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does this podcast establish an attorney-client relationship. Reference to any specific product or entity does not count as an endorsement or recommendation by Shahardy Sherman Williams. The views expressed by guests on the show are their own, and their appearance does not imply an endorsement of them or their entity that they represent. Remember, please consult an attorney for your specific legal issues.